itagat kala jita kala jin ko bertana tan boy nebo the corner office in Cas TV igista miten ko botam professor and the korago secretary ago CEO Jack Mwimali and that ko teljin and teljin council not nebo CLE and imit not na Kenya so biti buye changor missing go ba ngale ke ba somanet kama nutin ngone go not ni tagat so bit kedesta angla lanyon and riding. Welcome back, Prof. And before we took a break, we were talking about accreditation, you know, the time turnaround. Now, we want to move a little bit and we talk about training because I think this is the major part of this our conversation today. Looking at the training, I know we've set the background, we've set the foundation, first with the accreditation and then the whole process. So maybe you can take us through the training part and then we look at the examinations. Yes. Prof, welcome.
Thank you so much. One of the things that I pointed and alluded to is that when it comes to training, council is not the trainer. Under the Kenya School of Law Act, it mandates Kenya School of Law to train. But in terms of mandate, both Council and Kenya School of Law have the mandate to create the curriculum for training. The acts, Legal Education Act and the Kenya School of Law Act, do provide a framework of which courses, which units need to be taken. As I have pointed out, there are 16 units at the universities. There are 9 units at the bar level. So if you're going to be trained at Kenya School of Law, you have 9 units under which you are trained. But then we come in to examine. And one of the major challenges I know the public has been worried about is the diversification of that process. Because at one time somebody else trains and then at another remove another person examines. And therefore sometimes the expectations are not at par. So when Kenya School of Law is training and Council of Legal Education is examining, we may not be on the same wavelength. We have tried as institutions to work together so that even as we develop the framework, including the curriculum, even as we admit those students to Kenya School of Law, we come together, have a clear framework of how we will deal with these institutions, and the candidates who are coming from the various institutions who then come to Kenya School of Law. We share the previous questions that we have set, the performance in those questions, the expectations that the examiners had, and I've told you it's a rigorous process. So we bring it to the attention of Kenya School of Law so that they use it even as they develop their training guide at that level. And therefore it improves the quality. The advantage of diversifying the setting and separating it from the training is that then you have a standard system irrespective of where that candidate has come from, whether you've come from abroad, whether you are at a university within the capital city, Nairobi, or from a rural university. And we have quite a number because of the requirement of devolution, a number of institutions that offer law in various areas. For example, now we have accredited Tom Mboya. We have Maseno University in the Western. We have Chuka University in Chuka. We have Southeastern in Kwavonza, in Kitui, and so on. So when we are examining, we want to guarantee the public that the quality of the advocate, irrespective of whether they have come from abroad or from these universities I've mentioned, from diverse corners in the country, have the same capacity to represent you in court. And that being the case, then it is good to have that diversification so that you are not just being trained and replicated as an advocate, so that that creativity is lost. But nonetheless, it's one of the major concerns that we have been having, and that is how we have tried to address these concerns to ensure that the standardization there's quality, but there's also equity and parity in the way we treat the candidates who come to do the bar exam.
Absolutely. When they come for their bar exams, very, very important, Professor. Now, looking at the exams now, I know, and we'll still have a conversation around it, because when you look at other universities on different fields in terms of how they set their exams, that quality, as CLE, how do you ensure it's meeting up to the standard needed? Yes.
We do it threefold.
Okay.
As I've mentioned, first of all, we have very stringent requirements for the legal education providers. Mm-hmm. We have a set criteria that then we employ to ensure that any applicant for license to offer legal education at the university level, at the undergraduate level, has the requisite qualification. Mm-hmm. If you do not meet, then there have been situations where we have been forced to intervene in the case of university. Sometimes we have refused to accredit them until they met certain qualification. There are times we have even gone as far as taking the drastic action of closing those institutions. Our intention is never to close an institution. In fact, as a policy, our approach now is to work with those institutions to ensure that they can guarantee that quality at that level. So if there are limitations or shortcomings, we are normally keen to get to plan and arrange with the universities to ensure compliance. Of course, when it becomes absolutely impossible to guarantee that quality, then we will have to shut that institution down to ensure that we do not produce people who cannot then meet the market demand at the university level. And then, as I have said, at the examination level, where we now train the bar exam, we ensure that, number one, you have also all the qualifications that are required for the practice of law in the areas that are specified in the Act. And then if you have that, we ensure that we guarantee that quality through curricular formulation at the bar level. So we are talking at Kenya School of Law, where we work closely with them, even though we are their regulators, to ensure that the curriculum under which they are training is one that is fit for purpose. And at the moment, for example, we are having a process of trying to ask ourselves the question, in 3 or so years' time, we'll have these individuals who are coming from a different curricular system or education system, the CBET. How then do we, as universities and as Kenya School of Law and CLE, ensure that we cater for these people? Again, it will probably necessitate a review of the rules and regulations, a review of the curriculums, and we are working with these institutions to just ensure that we align those so that when these come, we are able to meet them at that level. Again, for us, we are working within the current society. We are alive to the changes in the society. We are alive to the global needs. And I'll give an example. There are people who come from institutions that are not Commonwealth. You come from France, you have a law degree. You come from Russia, you have a law degree. Initially, the structure of legal education and training in Kenya was to only recognize those who come from Commonwealth countries. So if you are from England, US, South Africa, Canada, Australia, we would not have any problem with you, Uganda, Tanzania, because the system of law in those countries were developed in the same manner. India, they were developed from the colonial past with a close link to the United Kingdom system, the England and Wales system. But the reality of current world is the practitioner is not going just to be limited to the Commonwealth practice or common law practice. For example, China is becoming a very dominant power in the world. Yeah. We import a lot of cars from Japan, where we have contracts that are made with those countries. We have contracts with France. Recently, the president of France has been here. There have been certain agreements between the government of France and the government of Kenya. we have come to the realization that we also need to regulate in line with these global realities and changes. Some of the answers I may not give, but I'm pointing it out to show that Council of Legal Education is alive to these realities. We are regulating with the situations that we are in, so that ultimately we will not want to prevent you from being an advocate simply because you went to Germany, Canada, or you went to Sweden, where they did not teach you in the same way we teach our law program here.
Law program,
Yes.
Absolutely. And looking at, Prof, different profession, we talk about even doctors, we talk about teachers, we talk about any other profession. And there's this word being used around, like, let's say a quack doctor, and then a quack lawyer.
Yes.
So what is the council doing to ensure that whoever is out there, because I know we've had so many cases in the media, looking at people, someone just goes to like high court or whichever the court, just being around there and like, I can offer the legal counseling, I can do helping the public, but in the real sense is that person is maybe in one reason or the other, drop out, or even never went to a law school. So what is the council doing about it to reduce and maybe to weed it out, completely?
Now, one of the things that we need to point out is the disparity in terms of mandates, because now the domain of ensuring practitioners come from qualified people is the one that is vested in the Law Society of Kenya. Again, the Law Society of Kenya is distinct from Council of Legal Education, distinct from Kenya School of Law, but they are the ones that regulate or have the membership of all the people who are licensed now to practice as advocates. For us, we come in at the beginning. But having said that, we also play a very critical role in determining, because number one, for persons who have qualified, we need to gazette them, including those who come with foreign qualifications, as I've noted. We work together with the Office of the Chief Justice, who then admits the advocate, and we normally supply that information to the Law Society of Kenya, so that we maintain a clear framework of who is qualified to practice. Have they undergone through the relevant training, or have they been exempted? Because the law allows us to exempt persons, and as I indicated earlier, so for example, if you come from having practiced in the UK, there's no need of us subjecting you again to another level of training, and yet you have been a practitioner, you have been trained, and you have worked in Uganda. Of course, before you work in Kenya, there are qualifications that would need to be had. You may come in as an advocate of that country with special license from both the courts and the Law Society to work in a particular case, and you work with a local advocate. That's permissible, it's allowed, and that CLE normally has no role. But you may be coming in now to open a firm to practice in Kenya. Then you need to have met the qualifications under the Legal Education Act, specifically, not the Legal Education Act. For qualification is the Advocates Act. It provides in section 12 and 13, for the qualification of one to practice, you must have in section 13 been admitted after having passed through the examination offered by the Council of Legal Education, or having been exempted as per the provisions of that section by the Council of Legal Education. But there is also section 12 that requires that you must be a national of Kenya. There's a provision that also allows those who come from, in that section 12, who comes from Tanzania or Uganda, because again, because of the Commonwealth and the East African Community system, we have a very close structure. There was a law that allowed or expanded that list, that you can also be a national of Rwanda. It included also Rwanda, Burundi, Tanzania, Uganda. Now, since then, there were admissions to the East African Community of Congo, the Democratic Republic of Congo, and South Sudan. And the question has been, it has been litigated even in the courts. Do you allow Tanzania and Uganda and Rwanda and leave out those who are coming from South Sudan, leave out those who are coming from Congo? That's a question that can only be addressed by the legislature, parliament. They must legislate to change. If they want a practitioner from East African Community, then they must say so expressly in the act. But again, you'll find that many of those who come and want to be admitted in Kenya may have stayed in Kenya for a long time. For example, the South Sudanese students or candidates, they may have come in as refugees, they have been trained through that system, and therefore they have all the qualifications, but they are left out by virtue of that provision. Those are some of the challenges that need to be streamlined, but having said that, it is a legal process, and we work very closely with the Office of the Chief Justice and the Chief Registrar of the Judiciary, because they maintain they are the ones that admit, and they maintain a list of those who are admitted to practice. And of course with the Law Society, again, because it's their mandate to ensure that practitioners do qualify. They also offer continuous professional training.
Absolutely. And a quick one, Prof, before we take a break. You've mentioned at some point, like in a bad situation, a school, let's say school A or B, can get deregistered to offer maybe a specific, to offer a course.
Yeah.
And what are some of the scenarios? Let's say if this school A or B was accredited at first, they
Yes.
had met the requirements, and then maybe the kind of education went down, and what are some of
or those parameters are not met.
Yes.
For example, and the live situations that we are currently facing is a situation where when we come to accredit you, you have sufficient number of lecturers to train the students.
Yes.
Then 6 months down the line, either those lecturers go for greener pastures, so that at the end of it you don't have the qualification, or we accredit you to take 100 students, then somehow you go and take 200 students. It is a challenge that we have been facing, and of course, as I said earlier, the mandate that we have permit us to deregister that institution. If you do not comply with those quality standards, there are situations. It happened, I think, 4 or so years ago when we had a problem with Moi University, and we went out and told them you cannot continue to offer that training. We even asked them to give us a closure plan, including how they're going to deal with the students that were already registered there. And even as we do take that drastic steps, which, and I really want to emphasize, it's not in the council's interest to close down this institution. It's in the council's interest to have them work within the framework that we have set, because it is entirely intended to create quality. So if you do not comply, you put us in a problem, because we would have accredited the other institutions, they have sufficient number of students. How are we going to deal with the students already admitted? So in many cases, we would tell you, you cannot take any new students. If you do take them, we'll not recognize them. And we give that clear information. And then we look at modalities of you either teaching out those who are in the system, but ensuring that even as you are teaching out, you have the sufficient number of, say, lecturers, the facilities to teach out. But if need be, then we may even transfer those students to other institutions where they can assure and guarantee quality. So council is mandated and has the power to do that. But by the time we get to that drastic state,
Point, yes.
we must have ensured that the institution does not or is not able to meet those quality standards that we have set.
Absolutely.
So we normally encourage, and at the moment we even tell those institutions, come have a meeting with us. We understand the economic and financial situation in the country. You may be struggling, for example, on retention. Planning becomes ideal. You may say, for this semester we are not able, but we can guarantee that because we have this number of lecturers, we'll teach this group. But come, say, September, when we have a new intake, we'll have another 3 lecturers brought in so that they're able to. So we do the planning with them, and we enforce those promises, because then it means it allows you time to develop the infrastructure to ensure that you guarantee that quality and also do justice to those who are already admitted. Otherwise, then we will face a situation, and it has happened with, say, engineers and even lawyers, where the institutions have worked completely against the regulations that were given to them. And when the students graduate, the board, in the case of engineers, the council in case of legal education, we tell them, you are not qualified to join the bar because the institution from which you undertook that program wasn't accredited at that time.
Absolutely. Thank you so much, Professor. Given the break, we got the corner office in CAS TV.